Great. Well, Yasmin has a secure tenancy. We know this. She's been taken to court already and she's broken a suspended possession order. So now she'll be evicted by the court bailiffs in 3 days. Is it too late to stop this? And yeah, what can we do?
Remember that if the court has discretion, then that discretion lasts up until the time that Yasmin is actually evicted. So it's still possible, if the court's got discretion, to apply to court to suspend that eviction. And we're going to come on to look at that now. And we'll look at the steps that the landlord has to go through in more detail to see what the court has to consider at those different stages. What are the opportunities to keep a tenant in their home? As well as at the end of this process with the actual eviction, what we can do at this late stage to help Yasmin. There are special rules that relate to possession proceedings of COVID-19 that we'll look at, that are delaying things and are affecting how court hearings are dealt with, and that in practice are going to give a little bit more time than usual for Yasmin to respond to this. And we've got general suggestions in responding to threatened eviction in more detail. Remember, the three main things the landlord has to do is issue a notice, get a court order, get a possession order, which entitles the landlord to evict, and then ask the court bailiffs to actually carry out the eviction. There's two main kinds of notice: a notice to quit, which brings the tenancy to an end, or a notice of seeking possession, where the landlord's having to rely on grounds for possession, and it's up to a judge to decide if it's appropriate for the tenant to lose their home or not. So the notice runs out, the tenant's still at the property. What next? To get a possession order, the landlord has to apply to court. The court will send a summons for possession to the tenant, and the tenant has a right to reply to the information that's on the summons and on any particulars of claim to go with it, detailing what the landlord's claim for possession is. Whether or not the tenant fills in the reply to it, there'll be a court hearing typically, where a judge will decide whether the landlord should be granted possession. Now, if the judge has to grant possession, then remember the court can delay possession for up to 6 weeks if the tenant would suffer exceptional hardship. The time given by the judge runs out. The next step is the landlord applying back to court if a tenant's broken the terms of a suspended possession order or is remaining at the property after a possession order takes effect. So the judge authorizes the bailiffs to act, and the judge's authorization is the warrant of possession. Then the court writes to the tenants or any other occupiers saying there will be an eviction at a certain date at a certain time. If you're not out of the property by then, the county court bailiffs will be evicting you. There's no choice about that. In practice, if someone was refusing to leave, the county court bailiffs could arrest someone for contempt of court, essentially, remove them from the property, and then help the landlord to secure the property. So that's it. And now we'll look at these steps in a little bit of detail. And this just summarizes what we've said. The notice to quit ends a tenancy, but the landlord must have given a lawful notice. Notice seeking possession doesn't end the tenancy because it's up to a judge to decide that the grounds for possession have been satisfied and the landlord's entitled to an order. And here's the example notice, section 21 notice. It's a standard form that you can download from the internet on the Justice website. It's included in useful resources. And it gives the address of the premises at the top, information to the tenant about how long the notice is valid for, the details of the landlord and their address. It must be signed and dated by someone who's authorized to do it. So it could be an estate agent or a letting agent acting on behalf of the landlord, or someone else, providing there's evidence they've been authorized to do it. And key issues are, firstly, has the notice given enough notice? So for a short tenant, it's typically going to be 2 months. And for other tenants, it could be shorter, or in some cases, it could be longer, depending on grounds for possession that are being relied upon. And again, because of COVID-19 restrictions, the notice may be a lot longer than that in practice currently. Remember, we talked about whether or not a judge could stop an eviction for assured shortholds if they've been given notice. Well, there are four main reasons why a landlord may not be able to rely on a Section 21 notice, even though they've completed it correctly. So firstly, if your property is a house of multiple occupation that hasn't been correctly licensed, the landlord cannot issue a Section 21 notice to bring your contract to an end until your property is licensed. They could still evict you on grounds of possession if a judge agrees that the ground of possession has been satisfied, but they can't just give notice to bring your contract to an end. If you're in doubt, contact your local council to check whether the property should be registered or not. Secondly, if you've paid a deposit to your landlord and your landlord has failed to properly secure it or give you information on how the deposit has been protected, then again, the landlord cannot issue a Section 21 notice until they've either returned your deposit to you or they've properly protected the deposit. Thirdly, at the start of your tenancy, private tenants should be given a copy of How to Rent, which is a short leaflet that's available online on the Gov.uk website. It's free to download, but you should have that information. It also gives you as a housing advisor a lot of useful information for advising private tenants. Tenant hasn't been given that, and the judge is satisfied they haven't been given that, that could invalidate any Section 21 notice. And finally, revenge evictions. So I'm a tenant, I've complained to the landlord the property's in disrepair. So the landlord, rather than deal with the disrepair, they give me notice they want me to leave the property. Remember that if you're dealing with an introductory tenant, if they miss the review process with the notice, then the court has no discretion when it comes to eviction. And there is a review procedure that's similar for secured tenants who are facing a mandatory ground for possession for nuisance or antisocial behaviour. You're not going to come across that too often, so we're not going to cover it in the training, but it's worth bearing it in mind. Always check the notice, check what grounds the landlord's relying on, and whether the landlord's provided sufficient evidence of it. If you're not sure how to respond to it, then get specialist advice.
Okay, so good. But what if there's no agreement or a tenant doesn't contact the landlord?
Well, the next step would be the court issues a summons for possession, but most of the information is going to be filled in on the particulars of claim for it by the landlord. And a tenant will be summoned to a hearing set at the county court that's local to the property. So it doesn't matter where the landlord lives, what matters is where the property is. That's where the court hearing is going to take place to give the tenant the best chance of turning up at court and defending it. That's usual, although there are restrictions due to COVID-19 that we'll talk about. And there should be at least 21 days from the date of service of the summons, that is the date when the tenant is assumed to have received it, to the hearing. If a tenant only received it a week before the hearing, they've got an automatic right to get the hearing postponed to give them adequate time to get advice and to prepare. And it's not the summons, but the particulars that go with it that explain what the landlord's claim for possession is about. And that's usually got all the information you'd want to be able to advise the tenant on how to deal with this. Very importantly, if you've got the opportunity to fill in the reply to the particulars, it's worth doing that because that reply is going to go to court. And if your tenant is facing eviction as an assured short-hold tenant, there may be no need for a court hearing if the landlord uses something called the accelerated possession route. And the clue that that's happening is if there's no date for possession set on the summons. There won't be a possession hearing unless the tenant fills in the reply, either disputing the landlord's claim for possession or asking for more time before they're evicted. In most cases, even with COVID-19 restrictions, there's going to be a hearing of some sort, even if that has to be online or by telephone. And here's an example summons, just so you're familiar with it. It's coming on a standard form. At the top of it, you may not be able to see, is the details of the court that's responsible for this case. And there'll be a claim number with this summons that's important for any communication with the court. It'll give the landlord's details as a claimant, the tenant's details as defendant, and the address of the property that is being recovered by the landlord as the next part. And then it will say when the hearing is going to take place and at what time. The back page of it doesn't give a lot of information. It's just a very brief summary of what the case is about, which may be rent arrears. But remember that for rent arrears, there could be a multitude of grounds for possession depending on the type of tenancy you're dealing with. It should be signed and dated by the landlord or someone acting on the landlord's behalf. And they sign this box which says his headed statement of truth, saying the facts stated in this claim form are true. And they also have to sign that on any witness statements or any information that's attached to this summons. So the particulars of claim has got the important information to look at. Okay, and it should explain what grounds for possession are being relied upon by the landlord. Then the tenant should be sent a copy of any evidence the landlord is relying on. So typically that'll be details of the rent, so a copy of the rent account, the latest rent statement, for example, detailing what the rent is, how much in arrears the tenant is, and what rent payments the tenant has made. Okay, but for the form itself, it's about 4 pages and some extra notes, but it's broken up, so there's not a huge amount of information on it. Just like on the summons, at the top of it, it gives the details about the court that's dealing with it and the claim number. The claimant has a right to possession of what property, who's living there according to the landlord. Question 3, for tenants, property is rented out to the defendant under an agreement, and it'll say typically what the landlord believes the agreement to be. So that's often telling you without needing to do all the working out to figure out, is this an assured shorthold or a secure tenancy, for example. How much the rent is and whether it's payable weekly or monthly or some other period. And then in question 4, they're asking why the landlord is claiming possession. In vast majority of cases, that's going to be rent arrears. And unless a landlord specifies a ground for possession, we could assume the court's going to have discretion not to make a possession order. If a landlord's relying on ground 8, compulsory ground for possession, you'd expect them to specify it. And if there are any other reasons for seeking possession apart from rent, you'd expect the landlord to specify which grounds for possession have been broken, or if there's a general breach of the tenancy agreement, what exactly is the clause that they've broken in the agreement, and then to give supporting evidence of that. So most of the rest of the form is giving standard information. You can ignore the chunk on forfeiture because it's going to be very rare that that happens in practice. If you saw a forfeiture claim, you get specialist advice. The back page, question 15, could be important in providing additional information. By and large, most landlords would give an attached witness statement summarizing key information. So you can go back and look at that at your leisure, and you can pause it if you want to. Now the court hearing. If you've been summoned to court for the hearing, you don't have to send in the reply form, but we'd strongly encourage you to. Because if you're not able to attend for any reason, then at least the judge has information to take into account in deciding whether or not you lose your home. If there's no defense and there's no question of any discretion, if the judge is satisfied with the landlord's evidence, they'll have to grant a possession order. Typically, a judge would give 14 days before you have to leave your home, but they could give up to 6 weeks, as we've explained. But remember, that's not the only time. They still have to get the court bailiffs to evict after that date. But if you move out within that time, it avoids the landlord incurring any additional court costs that you may be liable for. If the judge isn't satisfied with the landlord's evidence, they could postpone the hearing, they could adjourn it to a later date to give the landlord more time to bring any additional evidence or for the tenant to respond to that. And if the judge has discretion, the judge could refuse to make a possession order. We'll just summarize the different types of order that a judge could make. So if it's just a bit of time that's needed to sort out benefit or debt problems that are affecting a tenant's ability to pay, then a judge might adjourn it for a month, 2 months, possibly longer, to give you the time that's needed to deal with that. There may be no outstanding issues, but it may just be purely a question of saying the tenant's paying the rent, they've agreed or are now agreeing to pay an affordable amount towards the arrears, but do we want a possession order made in these circumstances? And instead of making a possession order of one kind or another, the judge could simply allow the case to be adjourned on terms as long as the tenant is complying with that agreement. Alternatively, if a judge decides the landlord is entitled to possession, but the tenant should get a second chance, a judge can make a suspended possession order or a postponed possession order on conditions, like for rent arrears, a tenant pays the rent plus, in Yasmin's case, £8 a week towards the arrears. So the landlord doesn't need to get a new possession order if the tenant breaks the agreement. They've got a possession order, the tenant breaks it, it would then go on to actual eviction if the tenant misses payments. Or finally, if the court's got discretion and they decide it would be completely unreasonable for this person to be at any risk of losing their home, or in the case of social landlords, there's been a big non-compliance with the pre-action protocol in dealing with rent arrears, the court could dismiss the entire case. Or, of course, landlords could decide themselves to withdraw the case if they decide they don't want to evict someone anymore. But even in cases where the court's got discretion, they may still decide it's reasonable to evict someone, and someone could end up with an outright possession order and just be given time to leave, same as before. Okay. And then the next step would be actually enforcing that order, and that's where we're at with Yasmin. So she's got the right to stay put until she's actually evicted by the court bailiffs, or she chooses to leave the property. So the landlord applies to court, the judge authorizes the eviction by granting a warrant of possession, and then the court writes to the occupants telling them when they're actually going to be evicted. This is an example eviction letter. A lot of this is local practice, so it may not look identical to this when you see whatever Yasmin brings in later. But generally, it's going to have this information on it. Okay. So, firstly, which court is dealing with the case, and the case number and the warrant number, so that when your client takes their application to court or sends it in, the court can match it up with the original possession order, so the judge has all the information to weigh up how to deal with this. When the eviction is going to take place, remember you must apply to court before the eviction takes place if you want to suspend it. If you've got this a couple of weeks in advance, you've got more time to prepare, but we would still say do this at the earliest opportunity. And even at this stage, it's worth contacting the landlord. They may not agree to suspend the eviction, but could give you useful information about what they know about the tenant's situation. The information they give you is going to inform you writing the application to stop the eviction. And there's always a possibility that they change their mind between the time you discuss the situation with them and the actual court hearing.
Okay, so provided that Yasmin brings her eviction notice with her, we should have this information. Great. But what if she doesn't bring the letter? What if she forgets it?
Then it's even more important that you speak to the landlord to get that information. Either the landlord or the landlord solicitor should be able to give it. Push comes to shove, you can always try contacting the court, giving the details of the landlord and giving your client's details. If your client is with you, they may be willing to share information with you. Otherwise, if you're having to do this at a distance with Yasmin, she may need to phone the court herself to get that information.
Yeah, and what do we have to do for the actual court application?
Very important, and that's what we're going to come on to next. So generally, at this stage, we're looking to suspend the enforcement of a possession order. With limited time to do this, I would think the focus here is on getting the eviction suspended. So we're going to do this on an N244 form. This does cost Yasmin. She would have to pay a fee to make an application to court, but she may be entitled to fee remission or not to have to pay a fee at all because of her low income. And she'll need to apply on a form EX160, which you can download from the Justice website. Okay, so let's look at the N244 form briefly. It's only a two-page form. Most of the information on here is going to be straightforward. Yasmin is the one making the application, but the claimant in this case, the one who got the possession order, is a landlord. The order you're asking for is to suspend the eviction. And in a case like this, there's quite a few options that are open to a judge. So we're going to give the judge the information in the supporting statement about Yasmin's situation and what can be done about the rent arrears and what we'd like to do if the court can give us more time. But ultimately, the judge will decide what's reasonable in the situation. So if we're not sure if it's a very open-ended situation, most important information is asking the judge to suspend the eviction. Attaching a draft of the order that might be suitable for a specialist advisor, and that might be part of the supporting statement or part of that box in the order for what you're asking the court to do. But I would suggest leaving that generally and ticking no. Definitely, I would say ask the application to be dealt with at a hearing. So if it's not dealt with at a hearing, the judge will simply look at what's in writing in front of him or her to decide whether or not to stop the eviction. At a hearing, even if it's a telephone hearing, the judge is going to have the opportunity to ask Yasmin further questions if there's anything else that might be relevant to exercising their discretion to stop the eviction. The only time a hearing is not going to be needed is if your landlord's already agreeing to stop the eviction, but they're insisting that the tenant puts in an application to stop it. Typically, a judge isn't going to give you long for hearing a case like this. 15 minutes is quite a long time to hear an application to stop an eviction, at least the first time the judge deals with it. The judge will read through whatever you've written, ask further questions, and you might be asked questions by the landlord at the hearing. It won't be agreed by both sides unless you've already spoken to the landlord and they've agreed this. The level of judge that can deal with this is basically any. Even if a higher level judge made the possession order, in exercising discretion, generally any judge can deal with this. So district judge keeps things nice and simple for the court in processing the application. Okay, and who should be served with the application is always going to be the claimant. Now, if you've got the opportunity, it'd be sensible when you're negotiating with the landlord, send them a copy of it. So they've got information in advance. Again, they can weigh up what they want to do before it comes to court hearing. The important bit to fill in for you is this white box on the back. And that's essentially all the information the judge is going to be aware of to carry out any discretion they've got to decide if it's reasonable to stop the eviction. If there's not enough space, you can always attach a letter to this, breaking down our suggested contents for that statement. And in a rent arrears case, it's usually good practice to include a summary of your client's income, their spending, and their debts. You can use a financial statement for this, or you can simply type out the information as part of the letter. Okay, so the important information in the most rent arrears cases is going to be, firstly, what their situation is. So we know some of that already about Yasmin. She's a lone parent with 3 children, and she's working but on a low wage. Why they broke the terms of the possession order? Is there mitigation? Is there a good reason for them not complying with the order? Even if there's no mitigation, if there's no good reason for it, what have they now done about that problem? Importantly, can they now go back to paying the rent and an amount of the arrears? Do they need more time to do that? Have they already got advice? Are they taking actions to deal with other debts to put them in a stronger position to pay? All of those things that are making it easier for them to comply with any future court order in this case. So what they're offering, if they're in a position to offer something towards the landlord. If you're waiting for benefits to come through and you can't pay the rent without that, without leaving yourself with no money to pay for food, you're not in a realistic position to offer to pay the rent. In that case, we'd be suggesting you need more time to pay and ask the court for time to deal with any benefit claim. The court could always set a future rent payment date, so you're not having to pay the rent immediately. Or the court could suspend the eviction and adjourn this case for a month or possibly longer to deal with any benefit issues. After eviction, remember there's nothing more that can be done to stop the eviction. Any discretion lasts up until the eviction takes place. You must get the application in before then. Very rarely it's possible for a specialist housing advisor to get the possession order or the eviction set aside but I really wouldn't rely on that. If the eviction's already taken place, consult a specialist housing advisor on whether the tenant can be reinstated, but advise the client to contact the local council and explain they're homeless. So, it's general guidance again. Avoid any possession order if possible. Check if the court's got discretion not to make an order. Even if the court doesn't, how much time is there before eviction? And can you get more time at the stage of a possession order? But now, with only 3 days in Yasmin's case, it's too late for that. Always talk to landlords, see if you can get an agreement to get more time or to call off an eviction. And refer your client for specialist advice and representation if you can't get an agreement. Most county courts have got duty representation services available for tenants at possession hearings. Check if your client has somewhere else to live in the event that they get evicted. Do they have family or friends they can stay with? And if in doubt, they should tell the council that they're going to be homeless if the court doesn't call off their eviction. Okay, so now taking into account all of this, how would you advise Yasmin? We can pause here, make a note of what you think you would advise Yasmin to do, and then we can go through this. So, Rashid, are you ready to advise Yasmin yet?
I think so, yes. So going through what I have, like we know she's a secure tenant in the local council and the bailiffs will evict her in 3 days. The court does have discretion to stop her eviction because they suspended her original possession order. And because they've got discretion, Yasmin can actually apply to court to suspend that eviction. And that's by completing the form N244. Because of her low income, she should also apply for fee remission, which is form EX160. But really, with only 3 days before her eviction, we should contact her landlord to discuss her situation. There's no point burying our heads in the sand. Yasmin should also apply as homeless in case the court doesn't stop her eviction. So a lot to do, but not impossible.
Okay, absolutely right. There's always the risk that someone could be evicted because the court has issued the eviction warrant. If the judge decides not to use their discretion to stop it, she will be homeless. So she should be starting to prepare. And I would always advise someone to pack up their essentials and have it with them. So they're ready to move on in the event that they're evicted in 3 days. And she can negotiate with the landlord to collect her belongings after, and landlords do have an obligation to safeguard belongings for a reasonable period. Okay, now some things to bear in mind: coronavirus and evictions. Generally, at the moment, 6 months notice is needed for all tenants, but there are exceptions for antisocial behaviour, domestic violence and rent arrears. All Section 21 evictions, that is for assured short tenants who've been given 2 months' notice, have been paused until after February 21st this year, 2021. It's possible that deadline could be extended. You would need to check the shelter advice pages on COVID for up-to-date information on that. Most other evictions are paused except for eviction connected with antisocial behaviour, domestic violence, or when the tenant owes 6 months or more rent arrears. Now, with Yasmin, if she owes £1,000 in rent, she probably already owes well over that limit. And now with extra rent, it's going to have increased. There are court hearings going ahead, but it depends on the local court how they're dealing with that. So typically the court will write to you if you're being summoned for a possession hearing with further information. Even at a distance, even with online hearings and telephone consultancy, there is still duty representation of a sort available. And you can find information on duty representation services for evictions through your local county court. And for actual evictions, like with Yasmin, bailiffs must give at least 2 weeks' notice at the present time. So although we know it's only 3 days from the eviction now, she's had it 2 weeks in advance. That's going to be valid. If it's less than 2 weeks' notice she's been given, she'd have a right to get the eviction delayed. Dealing with rent arrears specifically, firstly, we want to know that the court has discretion. Otherwise, she gets evicted regardless of whether we're able to reduce the debt or not. Check what's included with the rent, because if there are other amounts that are labelled that are collected as part of the rent arrears, but things like charges for repairs, or benefit overpayments that are just tacked onto the rent account, those aren't strictly rent. And if she's been moved by the landlord from a former property, any rent arrears owing at the former property don't count as rent at this property. Check benefit entitlement because many tenants in debt aren't getting all the benefits they're entitled to. And if a tenant is entitled to housing benefit or universal credit housing costs, check if that's being paid directly to the landlord. Otherwise, it may be increasing the arrears unnecessarily. Never offer what you can't afford. So that's important to know what her income, her spending, and her debts are. And that may be a reason to refer her to a debt advisor to prepare a budget, and also so the debt advisor can go through the options for dealing with the rent and the other debts together. In some cases, direct payments from benefit to pay for rent arrears are a good idea if someone's on income support, job seekers allowance, employment support allowance, or pension credit, where the deductions are a set amount. However, for universal credit, the deductions can be for up to 30% of someone's personal allowance, which can tip people into further hardship. So I wouldn't generally advise it for universal credit claimants, but I would for others. And in fact, the amount set as the arrears payment for deduction from benefits is pretty much the minimum a court would accept as an arrears payment anyway. So think about further advice that may be needed. Negotiate with landlords, even on apparently undefendable cases, if there's a way of dealing with any underlying problem, and refer for specialist help. So here's our suggestions for Yasmin's case. We know that she's a single parent working on a low wage. We'd want to know how many children she's got and if she's getting any child benefit or maintenance for the children. And we want to check she's getting the right amount of benefits in her situation. And we can do that online through the Turn to Us website. We'd want to know if she's still got other debts, because the money being used for those debts might be affecting her ability to pay the rent. Again, refer her for a debt advisor to prepare a financial statement and to go through her options with her. At the court hearing, because it's discretionary, we don't know for certain what a judge might do, even if she's got a sympathetic case. So it's always important to refer someone for future representation if it's available in your local area. Or if it's not available, refer her for specialist advice for getting the case as well prepared as possible. Finally, we hope it doesn't happen, but if she's homeless, she has children, she might be entitled to temporary accommodation from the council while they look into her case. There's always a possibility that a council might find she's intentionally homeless for getting into rent arrears. And that may be a reason for refusing to assist her in the long run. But they would still have to assess her needs and provide accommodation until they've completed an assessment. If they refuse to help, she can be referred for further advice. Okay, and lastly, for yourself, it's worth making a note in future, not in an emergency, to know where your local county court is and how to contact it, where the local homelessness services are and how to contact them, especially if you're not able to go with someone face to face or where there's COVID restrictions which might affect face to face contact. And as most possession cases do with rent arrears are connected with debt, know who your local debt and benefit services are and how to refer to them. And again, we've got those on the possession cases guidance. So that's about as much as I can tell you in the time available. You know the steps a landlord has to take to legally evict someone. And you know that in most cases, tenants have got more time than they think they do to stop an eviction. And even if this was on the morning she was due to be evicted, we can still help her to apply to court to suspend the eviction. And always refer for specialist advice if you need to. Okay, well, thanks very much, Rasheen. Good luck with this. And for anyone else who's watching, then we've got useful organizations and further information that's in the guidance. And you've got the basics to be able to at least identify what can be done to stop an eviction and the steps to take to help someone. Thank you.